Hi guys, it's Kathy. I hope you're doing well. So, I can't see. I'm trying to do this, but I can't see. We're going to start with Judge Middleton today, and then we're going to go over to Indiana. But Judge Middleton is just saying bye to us. Bye, actually, to his old courtroom. He's moving to a new courtroom. And let's just hope the audio works. That's all we're hoping right now.
All right, we're going to do a little brief sign off here. Thank you all.
There we go.
Hello, Mr. Lone Wolf. I see your channel from time to time. And others who are watching this. This will be the last live stream from this courtroom. We just took the last plea. As I indicated this morning, this courtroom opened about 1976 or 77. I get my days of years mixed up. When I first came here at the county in 1978, everything still smelled like new paint and new wood. Well, a lot of people have passed through here in the intervening almost 60 years. And it's time for an upgrade, a time for a refresh. And although we like things to be constant, they don't always remain constant. So we're going to be relocating. It isn't really terrible. We're going to be live streaming when I see everybody next from the historic circuit courtroom and the historic side of the St. Joseph County Courthouse. I have a nice corner office with windows that actually open. I don't consider it to be my office. I'm just warming the space for the judge that succeeds me. But it has been a privilege to practice in here. Lots of memories were made in here. I spoke of some of them this morning. So by the time anyone else does come to visit, this courtroom is going to be demolished. And that makes me sad, but it will be refurbished. And then in this nearly same configuration, it will have new bench, new walls, new carpeting. It will be new and perhaps last another 60 years. So that is not like they're tearing it down. And but everything in here is certainly anachronistic. It's like from the 70s, and I guess so am I. So we'll say what I said this morning. The three men I admire most, they caught the last train for the coast. That would be the Father, Son, and the Holy Ghost. So we'll see you when we come back in a new setting, at least for the next 8 months. And I wish everybody the best. We'll be back on the 21st.
So, changing courtrooms and saying goodbye to that one. Man, we had a lot of good times in that courtroom, didn't we? I don't play a lot of Judge Middleton, hardly ever, because he's a YouTube judge, and everybody else plays him extensively. But man, we had a lot of good times with Judge Middleton. All right, now I think we're going to Judge Frost right now. I don't know, and I'm the one who should know. I'm just double checking to make sure I put the right clip on. I don't want to put the same one on we already watched. We did that. Oh, maybe we're not going. This is the one I think we're doing.
On a phone today?
There we go.
Greg McEwen?
All right, can you hear me okay today?
Yes, I can.
I think I need your help, maybe.
All right. Can you see and hear me okay today, sir?
I can see you, yes, and I can hear you fine.
Good. Let's get started. This is 25 SC 5027, Gregory McEwen versus Randall Drager.
Okay,
For
no.
the appearances today,
This is
I
the wrong
have
one.
Ms.
That's fine. It's okay. I'll put the other one on. Kelly. Kelly, you feel good? You feel at all good, Kelly? Kelly, can we get you some chicken soup? That would suck 'cause you can't eat anything right now, can you? You can't even eat chicken soup, can you? Did it hurt? Are you in pain? It's really good to see you. I hope that they took extra care and did a really good job. I hope your recovery is not that terrible. Bren, I was looking today because you talk about like house prices in Sydney and everything, so I started just looking. Guys, if you go to look in Australia for like apartments and things like that, it's by the week, which I didn't know at first, which made everything I looked at different. So it's like when it says $400, $1,200, $4,000, that's per week. The rent is per week. So if you're looking at apartments and you see one for $400, that's not per month. That's per week. But there were some affordable apartments. I didn't look at houses because that's ridiculous. But you can actually move to Sydney if you wanted to. Guys, you would just have to make sure that you don't think you're getting an apartment for $400 a month, because that's not going to happen. $800 a month, I think, is the lowest I saw. And they were actually really nice. They weren't broken down. They were really beautiful. Beautiful. All right. This is not the right clip. We're going to move it to the next one. Boom. Okay.
Good afternoon, Attorney Myris. Can you see and hear me okay?
I can. Thank you, Your Honor.
And on the iPhone, could you unmute and let me know who you are, please?
Douglas Morgan.
A month, Kelly.
Great. Can you see and hear me okay today,
Hi,
Mr.
Lucy.
Morgan?
Yes, I can.
All right. We are here to talk essentially about the case and hopefully about scheduling it. We had a non-appearance last time we tried to do scheduling, and then I had to reschedule a couple of times. We're here today. So, Mr. Morgan, are you ready to schedule this case out now?
Yes, I am, sir.
Attorney Myris, how about you?
Yes, I think we're prepared to proceed.
And Mr. Morgan, how involved is it going to be for you to get your case ready? Do you plan on having very many witnesses or any expert witnesses or things like that?
No, I'm just basically coming on speaking in my defense with the paperwork that I have. Like you said, it was not like you said, I was by myself. So for me to have a witness, it would be hard for me to call because it would be their employees, in which I know their employees would not do that. So I would have to just move forward with what I know to be true.
Okay. You can subpoena witnesses, so
But
you could work with the defendant to try to see if they agree on having some of their employees show up, and if not, you do have rights to issue subpoenas potentially.
what I'm saying here is, again, it was like, again, it was a gaslighting moment. So I know that they would not participate because it would cost them their employment there probably. So I would want to jeopardize nobody's employment like that.
Okay. And do you need time to prepare for the trial, or are you ready as soon as we can get you on the calendar?
I I have me and a couple of my staff members have put some things together, I think, yes, we can proceed, or we can be ready when the date that you give us for this matter.
Are you planning to issue any discovery to the defendants?
That's what I've talked to my team about. So that's what I'm saying. When we get the date, we should be able to know when we can submit up the paper, like you say, our exhibits and our paperwork on what we feel that we can submit.
Sure. That's a slightly different issue.
Oh.
So discovery is where you ask the other side to give you papers or answer questions in writing or admit to things. Are you planning to issue any requests to them to respond?
I think we have already asked them for what they had and what they was giving us. And I think we can't ask for no more than that, like you said, from what they have given us, you know what I'm saying? So that's why I'm going to work off what they have already submitted to me.
Okay. Yeah, I mainly ask so I know if I should give you time to do any of that. And it sounds like you're not asking for it, so that's okay.
I truly appreciate you because you have, like you said,
Miguel.
been very
Hi,
patient with
Miguel.
this case and helping us to move forward and helping me to move forward with this incident. I'm truly grateful for that. And thank you again.
Of course. Attorney Myris, what about from your perspective? Is your client ready to go, or do you need to do any discovery or anything like that?
Judge Frost, yeah, so we are still waiting for responses to an initial set of discovery that we served in September. Also on the docket, hopefully today, we did also file a motion to compel. So we would definitely need plaintiff's responses to our interrogatories and initial requests for production before we'd be ready to move forward. And potentially, we would need time to take his deposition after that as well.
Mr. Morgan, I do have a motion to compel that was filed back in November. I assume you got a copy by mail of that, correct?
Yes, I've been working with, like you said, I've been busy. I've been doing a lot of court cases. As you see, I've gone through a lot of court cases and been dealing with the court system very extremely late. It's been extreme. So I'm trying to catch up with myself. Like you said, I have so much court cases going on, but I have a good staff members where tomorrow I'm supposed to sit down with them at 10 o'clock. And like you said, I will relay this message so that which again, Trident has been reaching out to these people, which is Guyers and Holmes, for this information. And which again, if she needs anything, they have already addressed to her that they could send her and we could figure out what she needs from us and we can submit it to her.
Well, you would have received the copies of, it's called interrogatories. There were also requests for production of documents. And you would have received that back in September, I believe the motion said. Do you remember getting that quite a few months ago?
Again, yes, I recall it, but again, I told you I have so many different cases that I just can't focus on one right now. So then again, I have tomorrow, like I said, I got an open day with some counselors that I can sit down and figure this out. Like you said, what I just need to know they should have the paperwork that happened in September. That's what I'm saying. So I'm going to them tomorrow and figure out what she's asking from them so we can submit that. Do that make sense here?
I hear what you're saying, yeah. So you agree that you have not provided written responses to the interrogatories and you have not yet provided the documents, but you plan to do so in the very near future?
No, I don't know what has been done at this moment. That's what I'm trying to say. With the counsels that I've been working with, I don't know what they have done or what they have submitted to her, but we have some paperwork that has been.
Don't go pro se, guys. Don't do it. Ever. Don't. No, Kelly, I got an allergic reaction and I went to urgent care. And they put me on prednisone. And the last day I got done taking that, I got another allergic reaction. So I was all unswollen, and then I touched something I wasn't supposed to again. So now I'm all swollen again. I'm not going back to the doctor. I can't afford another trip like that. No. So now I just have to wait for Mother Nature to do it for me.
That you said I have been getting, but like I said, I got so much mail. At this point, they let me know, like today, they let me know, make sure you make the call so that we can make the date. So that you can make the date. So when they get to you the date, we can go from there. Now she's asking for paperwork for extended time. Okay, we weren't looking for that. We were looking for, okay, if we have to proceed, then let's proceed with the information that we have.
Mr. Morgan, I'm a little confused who you're talking
I
about.
do now.
Is it an attorney
Linus,
that's going to
I
start
do now.
representing you, or who are
No,
you?
they sit on the side as representing counsel. They like represent me as counsel, helping me to learn how to do it for myself. They like sit on the sidelines and say, look, this is how this go. This is what you got to say. This is the paperwork you got to submit. All these things I'm learning. This is a new thing for me. Like I say, this is something I have not tried in my life. Never been to, like you said, I have been to some procedures, but I'm learning how they actually go right now. Like I say, I'm not been to school for this or anything. So it's
Yeah, we know.
I'm learning from, yes, some people that went to school, which is counsel and lawyers. And they're showing me the best way they can because they can't represent me because there may be a conflict of interest in other things.
Okay.
Guys, you want to know what I'm not allergic to? Ghirardelli. Intense dark sea salt. That's what I'm not allergic to. That's what I'm going to eat right now.
Attorney Myris, how long are you asking for me to give for a response to your requests?
I mean, respectfully, Your Honor, these responses were due initially back in October. We've experienced significant delay and expense in continuing this case during this time period. So pretty much as much of an expedited timeframe as you're willing to provide. Hopefully no more than 30 days or so.
Yeah, definitely no more than 30.
Yeah.
It should take that long, no way. I don't think that, like you said, after tomorrow, I could be more punctual. Like you said, tomorrow it would make me more punctual because I would actually know how to proceed and everything else. Like you said, I didn't know about, again, you have to excuse me, and I thank you again for being patient and understanding on what I'm going through. So, like you said, tomorrow when I get my date and she's saying within 30 days, I think we can meet her demands.
So, sir, do you still have a copy of the
Exactly,
interrogatories
JK.
and
Exactly.
requests for production? So you're going to bring that with you tomorrow with whoever is helping you kind of navigate how to respond?
You saying tomorrow?
No, I asked if you're going to bring it with you when you meet with that person.
They already have it in the law firm. They should already have this information. All my information, I give it to them immediately. So they should have this information already. That's what I'm saying.
Okay.
He's going to
Yeah,
be
it's
punctual,
It's already
David.
filed in the law firm. What I'm saying, it should be already filed in the law firm. Right now, again, I'm not a lawyer. So I'm acting as pro se for myself. So at this time, I'm, like you said, learning
Yeah.
to the best of my ability. And I'm, like you said, I'm not the smartest cookie in the bunch, but I do know how to grasp some things and catch on where I can hopefully get understanding that I need to make me satisfied.
Sure. Attorney Myers, I think what I'll do then is I'll order Mr. Morgan to provide complete written responses to the interrogatories and requests for productions by no later than 3 weeks from today. So I'm going to give you the exact date for that, Mr. Morgan. It's March 23rd. You need to make sure you get all of that to Attorney Myris's office so that they can have your written responses and any documents that you need to produce in response to those requests. Okay?
Yes, sir. And thank you again. Is there anything else?
Yeah.
March 23rd. March 23rd, is that a time?
No specific time, just on March 23rd. No, I guess by the end of the business day. Attorney Myris, would you like me to proactively
He doesn't joke, but sometimes he lies like a rug.
pick trial dates, or would you rather get the discovery and then come back to talk scheduling once you see what's in there?
I think a following up scheduling conference would be best for our purposes. Thank you, Judge.
Yeah, let's do that then. So we'll put that on right now as long as I have both of you so we can make sure it's on everyone's calendar. It's going to be either at the end of April or in May, just because of my own calendar after the 23rd. And by then, hopefully you'll know if you've needed a deposition or maybe you will have already accomplished it. Ashley, what have we got sometime after our trial?
We can do Monday, April 27th at 11 a.m.
April 27th.
That's because today it's not about food. We're starting food early, Michael. But today it's not about food. It's about self-soothing, and that's what we're doing. We're whipping out the chocolate and the key lime pie to make us feel better.
At 11
Yes.
a.m. Yes, I'm on board.
All right. Attorney Myris nodded her head, so we'll schedule it for that day. It'll be by Zoom again, and at that date, the goal will be hopefully we can pick a trial date and set any deadlines ahead of it that we need to. Anything else for you today, Mr. Morgan?
No, I appreciate you again, and you enjoy your weekends, man. Thank you again. Until we meet
Thank
again.
you. Thank you, you as well. Attorney Myris, anything else for you today?
I think I just want to note quickly, if this discovery continues to be an issue, we will be pursuing expenses.
Sure. So are
Yeah.
you
So the judge is ready to give her expenses right now. Don't worry.
not requesting it right now? I'm granting your motion.
Thank you.
He didn't provide any responses, so I've granted the motion to compel. I've ordered him to provide the responses by March 23rd. Am I understanding you're not yet asking for any fees?
Excuse me, I'm on SSI, so again, I don't know how she would collect fees when when the state automatically is governed to help me with my proceedings. So again, I'm not understanding that when you're trying to that's called retaliation. But okay, I get it. I need to go talk to these people. Is there anything else that I need to be on here for?
You should remain on the whole time
Oh,
we're on a hearing, please.
all right.
I mean, you can leave if you want,
No,
but then
no, no, no. I
you
wouldn't
won't
disrespect you.
hear.
I wouldn't disrespect you. Like, thank you again.
Attorney Myris, were you asking for a fee award today?
I do think that given the timeline of this delay, fees would be appropriate here. Though I understand that proceeding against pro se party, there are equities in the balance, but I do want to make it clear to plaintiff that he needs to be wary of these deadlines moving forward. And if fees are necessary, yes.
Why you keep threatening me with that? We just talked about. You keep threatening me with something we already talked about, and I said I'm going to try to get to your deadlines. I have no problem with meeting that. With that being said, is there anything else I need to hear?
Sir, it's not a threat.
Hi,
Our
Miss
statute
Murder.
says if a
Hello.
party
I
has to move.
understand that, but she
No,
keeps saying,
please don't interrupt me.
Oh.
If a party has to move to compel discovery, they are entitled to ask for fees. And by statute, they're actually entitled to have an award unless I find after a hearing that I can find any number of things, but there's only limited circumstances where I'm not allowed to award fees. So they're not doing anything inappropriate by asking for that today.
Yes, she was. She was threatening him, Judge. Threatening him. Miss Murder, are you from Australia? Are you Australian, Miss Murder?
Attorney Myers, you are asking for it.
Yes, Your Honor.
Do you know the amount?
That I would have to look up. I'm sorry.
Okay. That's okay. Mr. Morgan, I would have to have a hearing on the fee amount under the statute. And it says I can award all reasonable expenses incurred in obtaining the order, including attorney fees, unless the court finds that the opposition to the motion was substantially justified or that other circumstances make an award of expenses unjust. You didn't oppose the motion, so I can't find that it was substantially justified. I could potentially find other circumstances make an award unjust. And honestly, based on what you just said, I would probably have to hear and receive a little bit of proof about your financial circumstances. If you could prove to me that that your sole source of income is Social Security, I may have to consider if it's unjust to order you to pay attorney fees or to order you to pay all of them. But I would have to hear more about that. So are you asking me to put a hearing on, sir, so that you can present that to me?
Yes, I would at this time because again, I'm new. Like I said, I'm new to this. This is not something that I'm aware of when you're trying to get fair composition for what hurt you, for somebody hurting you. Like I said, I have to go talk to counsel because I did not understand all of this. And now that I do, this is something they didn't have me aware of before we even started this, when they should have had me aware of all this. But since I wasn't, like again, tomorrow, I got an
Whoa, whoa, whoa.
appointment.
Who was supposed to make you aware of all this? Who? You're an adult. You were supposed to make yourself aware of all of this. No one tells you what to do in your court case. There's no one. Oh wait, there could be someone to make you aware of all this. Hold on, I'm thinking. I think I came up with a solution, because there could be someone to make you aware of all of this. A lawyer. Go get a lawyer.
And I will be addressing this with counsel.
All right. Why don't we look then for a little bit longer period of time so I can hear, since there's a dispute about whether it's just or not for me to order attorney fees. I'll set a half-hour hearing to hear any reasons Mr. Morgan has to explain to me why it would be unjust to do that. So it could be anything that you think is appropriate to share with me, sir. But if it's going to be about your financial circumstances and how this might impact your ability to pursue your case at all, I would appreciate if you file any paperwork to back up your points that you're making, which could include proof of your Social Security eligibility, or that's your sole source of income or anything like that. So we'll pick a day and time for that, and then anything that you can get filed ahead of time that you'd like me to consider, make sure you file it at least 7 days prior to the hearing. Ashley, when could we put them on for a half hour? And we should just consolidate it with the scheduling, so maybe we should do 45 minutes and figure out a day where we have
Okay,
that.
that's what I was gonna ask. We can do Tuesday, May 12th at 9:30.
Mr. Morgan, does that work for you?
Will you be able to get a lawyer by then,
Like I
sir?
said, I gotta look over these days, but that should, if it's not aligning with these other cases that I have. If it don't align with that, you know what I'm saying? If not, I will reach out, like you said, if I have to. But by then, like you said, I'm trying to get this stuff over, so I'm gonna be working pretty swiftly to make this happen, man.
Sounds good. Yep, and always let us know if you realize that the date doesn't work and we'll reschedule it.
It's much bigger.
Attorney Myers, does that work for you?
Much bigger.
I believe so, Your Honor. We'll be in
Okay.
touch if there's a conflict in the future.
All right. Okay, we'll get out that notice of hearing. Attorney Myers, can you upload a short order about the granting the motion to compel and the 3-week deadline?
Yes, Judge, I can do that. And just to be clear, there will be no follow-up scheduling conference on April 27th then, just the May 12th.
Exactly, we're
Okay.
consolidating to May 12th. Yep.
There's no April 27th.
Nope, we're getting rid of that now and we'll just do it all on May 12th. All right, thank you both. I hope you have a good rest of your day.
Yeah.
Thank you.
Thank you. Good afternoon.
Good afternoon. Good afternoon. Counsel, can you tell me how do you pronounce your last name?
Rubes, Your Honor.
All right. Can you see and hear me okay today?
Yes, I can. Thank you.
And then Miss Gayton, can you see and hear me okay? Ma'am, you're muted. Could you unmute, please?
Hey, I can hear you just fine.
Perfect. All right, let's go on the record. This is 24 UC 634, the Department of Workforce Development versus Shireen Gayton. For the appearances today, who do I have for the department?
This is Andy Rubesum for the Department of Workforce Development.
Thank you. And then I have Miss Gayton appearing, both of you on Zoom video today. Ma'am, you're
Yes.
representing yourself without an attorney, correct?
Correct.
All right. I've confirmed we can all see and hear each other on Zoom today, and we're live streaming since we're on Zoom for this hearing. I put this as scheduling because I wasn't sure what exactly was going to be requested as far as what type of hearing or what we need. So I got the request filed by Ms. Gayton to have relief of some sort from the
Hi,
earnings
not
garnishment.
Jethro.
Is the department opposing that request?
Um,
Oh, ma'am,
they
I
were
guess I should
opposing it.
I
Oh,
should
okay,
ask
you can
you
ask them.
first. Are you still asking for that relief?
Yes,
Miss-
I am.
Okay. And Attorney Rubsam, is your client opposing that request?
Well, I don't know the court has jurisdiction, Judge. The case number for this case is 2024 UC 634. And that is not a real, it's a case number, but it's not a case number in the traditional sense because
No,
all it
it's not gone down
is
yet.
a case number
Working
for
on it.
recording our lien in the circuit court, kind of like a tax lien that DOR would file. So the purpose of the case number is just to alert the public that the debt exists. The case is not an earnings wage garnishment case. There may be a separate proceeding that we would then use to, for example, try to levy wages. But my understanding is that Ms. Gayton already has a prior DOR levy. And so I don't believe that we would get much, if anything, from a current levy with Ms. Gayton's wages.
So are you aware, is the department doing anything to garnish wages at this point?
I believe we may be attempting to do so, but I don't know that we are actually receiving payments right now. I'm actually going to check to see if we received any payments.
Okay, and is there a case number to correspond with that attempt, or what's?
No, Your Honor, it's an administrative, we use an administrative wage levy. So there's a
Yes, sounds
statute
right,
which
then.
is 108.225, which permits the Department of Workforce Development, and DOR also has this power to administratively levy wages without the need to go to court. And so if there are multiple wage levies, then whoever gets there first is usually the one that wins, so to speak. It looks like we have received a payment about 10 days ago for $179. But I can't determine if that was from a wage levy payment or not. So I guess at this point, Your Honor, I would say that the court doesn't have jurisdiction to tell us to stop our wage levy under this case. And if Ms. Gayton wants to discuss her wage levy with our collection staff, then she'd have to call our collection staff to do that. Because there's no cause of action here for the court to do that. This isn't a wage garnishment case.
I have psoriasis, but the medication for psoriasis is like 20,000 a month. I don't have health insurance, so I've been trying to, use other things. You can't really do anything about psoriasis, but there's this ointment that I've been using for years. Eczema and psoriasis symptom relief by Pure Remedy. It's an ointment. There's no smell. Okay. There is a little bit of eucalyptus, I think. But it's just, this is the problem. I've been using it for years, and now I can't use this anymore. Now I have just regular lotion to turn to again, which doesn't do anything for psoriasis. It's a joke. But that sucks that I can't use that anymore. That sucks. But that's the problem. That's the culprit.
Are you saying there's no right to go to court for any kind of review?
What I'm saying, Judge, is that
Pure
if
Remedy
Ms.
is what it is.
Gayton wanted to challenge our wage levy in court, she would have to bring an action to do so. And my understanding is that because it's an administrative process, there is not really a way to do that unless the debt is not owed by that person. There is an administrative appeal process that a person can use under 108.225 sub 19, which would go to an administrative law judge. But the only issues available on appeal for that would be, number one, the debt has already been paid, so the levy should not continue, or mistaken identity of the debtor. So if there's another person with the same name and we're levying that person's wages, they can say, I don't owe you the money. This other person with the same name owes the money to you. But we use a social security number when we contact employers about levying wages. So that doesn't usually come up as a reason for an appeal.
Ma'am, have you done any research about what law you believe you're proceeding under when you've filed this case and asked me to give you some relief?
Yes, Your Honor, I'm not refusing the responsibility. However, I'm currently below the poverty level. After rent, utilities, and food, I do not have disposable income. The garnishment is preventing me from meeting my basic living needs. I respectfully request deduction, suspension, or a waiver on hardship. I got a budget set up here, and I only make $2,800 a month. Like, in Dane County, according to the circuit court, it's a minimum of $4,000 a month to live comfortably. And I'm only at 2,800 a month, and I'm being like garnished from that as well. My rent is like $1,400 a month. So it's just a hardship part of me not being able to meet my basic needs because of this garnishment.
Sure, I hear what
Respond,
you're
Your Honor.
saying, but I'm more interested in, have you looked at any of the law about, so you used a form that applies to wage garnishments, which is a different proceeding. It's when a judgment debtor, so somebody who, I'm sorry, a judgment creditor, somebody who sued, got a judgment from a court of law, and now is trying to collect the judgment by garnishing wages. They have to do that through lawsuits and through a legal process. You filed a form that's the one that was created for asking for relief from that kind of a wage garnishment. It is different from the one that the department is proceeding with against you. And counsel had just pointed out chapter 108 being the chapter that's particularly applicable here, and 108.225. It does have provisions under sub 16, for example, for what wages are exempt from levy. And I struggle to believe that there's no way,
But
if the
yum,
department is
Michael,
just ignoring
yum.
that a party could never ask for any relief to insist that the statute be followed. But have you looked through any of those rules to do with the type of a garnishment you're dealing with here?
No, I'm just writing down these chapters and these sub numbers down now because I first originally just went to my job and asked, and they just tried to help me and told me this is the paper that I should file and take it through
Okay.
the court.
Okay, and that was probably the best info they had, because that's the more common kind that is often seen by different employers. So I'm not entirely sure how to proceed here either, Attorney Rubsam. I probably should have you file a motion to dismiss for lack of jurisdiction and see if Ms. Gayton wants to respond.
Well, it wouldn't necessarily be a motion to dismiss, Your Honor, because again, the case that we're here under, the case number is our case. It's a Department of Workforce Development filed warrant that tells the public that the debt exists. So I wouldn't dismiss that case.
No, you would move to
to fix-
dismiss her petition.
Okay. Just reviewing something quickly before
I guess what I'm saying is, before I would close the book on her, I should probably make you put your argument out there and give her a chance to look it over and respond.
I can do that, Your Honor. I think it'd be futile though, because I don't see any process here for
You got to
the.
understand where a court
I
sits, though,
understand.
which is just because you tell me it's so doesn't mean I have to just say, "Yep, he's right." I have to give due process to Miss Gayton. So it's frankly not helpful to
Okay,
be told that because I have
understood.
to sit here in a fairness role to her, and I have to decide if it's futile or not, not just based on you saying so, but also you pointing the law out.
Understood, Your Honor.
So when could you get some time?
Oh, burn. That was the most gentle attorney burn we've ever heard. But now he knows.
I could try to file something by next week.
Okay. Do you have a particular day in mind for me to put down?
The filing. Can I have until the 13th of March to file it?
Absolutely.
Okay.
Why don't I just give you 2 weeks from today, so March 16th? And then, ma'am, I'm going to give you 30 days after that to look it over and give me your written response, okay?
Right, so this does this do anything for the wage garnishment now? Does this pause it until this part is over with?
No, I have to see if there's even anything I can do before I would issue an order pausing. So you'll review what Attorney Rubesum presents, you'll do your own research and try to argue why you believe I can do what you're asking me to, and then I'll decide it after I get that all written out from each of you. And then counsel, do you want 15 days or a shorter period for any kind of reply?
Oh, that's fine, Your Honor. 14 days is fine.
Okay. All right, so 2 weeks from today, then 30 days, then 14 days, and we'll put a briefing schedule out.
Okay,
Okay.
Your Honor, one question I had is this case is not electronic, I don't think. And I don't think it can be made electronic because it's a lien filing case. So I think everything will have to be done through the mail. Just so that the court is aware of that.
My clerk tells me that's correct. Yeah. Yeah, I appreciate that. So, Ms. Gayton, you'll mail anything to the court, but you also have to mail a copy to Attorney Rubesum, okay?
I am aware, yes.
And he'll mail it to you as well when he files.
Okay, I am aware, yeah.
All right, anything else before I let you both go today?
So, with this administrative, this 108.225 thing, the Department of Workforce Unemployment, would they ever be willing to take a certain amount out of my check that I can agree upon instead of taking this big chunk out? Department of Workforce.
Do you want to respond to that, or do you want Ms. Gayton to reach out to you off the record?
Yeah, Ms. Gayton, if you'd like to call me when this hearing is over, my phone number
Oh, okay.
is, do you have my phone number? I filed the notice of appearance. I don't know if did you get that in the
I got
mail?
it now. You can tell me now, and I can just write it down.
Okay, it's 608.
Okay, all right.
Hi, Brayden.
I'm done.
Okay.
And Your Honor, if we have some sort of resolution to this matter, I'll file a letter.
Yeah, that'd be perfect.
With the court indicating that, I guess.
Yep.
Do a motion.
Okay. All right, thank you both. I hope you have a good rest of your day, and we'll mail that briefing schedule out to you.
Thank you.
All right, thank you.
Of course. Have a good one.
Probably for a credit card or loan. Probably one of those two things. But she's gonna lose that. But we got that because of how he choke slams the attorney. Okay. That wasn't a choke slam, but for me it was. Alright guys, now we're going to attempt to try this. Wait. Okay, so I don't know if you guys remember. Of course you remember. The other day we had that woman. We had that woman in, and she was loud And she was freaking rude. She hasn't seen her kids, blah, blah, blah. Okay, if you don't pay child support, your license gets suspended. I mean, it's just how it works. She, who loves her children so much that she's fighting hard for them, never has paid child support on them. Because that's not how the law works, she says. She says if she doesn't get to see her children, she doesn't have to pay for them. And we need to educate ourselves on the law, because that's not how the law works. Which we all know is a bunch of bull. Whether you see your children or not, you have to pay child support, because they still have to eat food. So she lost her driving privileges, I think, and this is the hearing with the Department of Revenue, ? About her driver's license being suspended. Here we go. I know. It does get better. The sound gets better. They're calling her out in the hall.
Ma'am, sit there, just remain standing, raise your right hand before us. Sir, you can sit back.
Do you solemnly swear or affirm the testimony you shall provide to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Thank you.
Thank you. You may be seated. Good afternoon. We're here in DOR on behalf of Justin Serlich and Heather Bindle. This is 2023 31828 FMCI. These proceedings are being digitally recorded by the Office of Digital Court Reporting. No other recording is permitted. We're noticed for hearing today on a motion to contest driver's license and motor vehicle registration suspension, only as to the issue of the driver's license and motor vehicle registration, as to whether or not a child support delinquency does or does not currently exist for the currently entered orders, and if so, Department of Revenue's position on the driver's license and motor vehicle registration. Document number 188 in the court file for everyone's reference. No other issues are noticed for today's hearing, and 15 minutes have been set aside for today's hearing. All right, so
I'm sorry, I'm hearing impaired. How much time is set aside?
15 minutes, ma'am.
Thank you.
I do have a copy of the arrearage affidavit. I'll try to speak louder if that'll help.
I appreciate you. Thank
Sure.
you.
I do have a copy of the arrearage affidavit and clerk's payment history. I'll take judicial notice of that, as well as of the rest of the court file. The arrearage affidavit says that there's $35,783.50 owed on the case. It says that of that amount, $4,710 of it is listed as what is called a ongoing child support delinquency on the $785 currently ordered ongoing child support payment for the children listed on this case. I do have a copy of the payment history, which shows that a writ payment of $1,000 was made on 3/24 of 2025, as well as a sheriff's $90 fee, as well as a $5.25 clerk fee. It does not list any other payments that have been made on this case, and I understand that you might disagree with the order that has entered, but is the order unless or until it is changed or overturned.
Correct.
So based upon the orders which have entered, do you have any evidence to present of payments that you have made on this case through the system as ordered for which you have not received credit, ma'am?
No, sir.
Okay, thank you, ma'am. All right, just for all of our information, because the court would like to know, and Ms. Spindle might like to know as well, I'm going to ask the Department of Revenue, what is the current status on Ms. Spindle's driver's license as we all sit here right now?
It's on hold pending the outcome of today's hearing.
So the license is still valid and it can be saved if an arrangement can be made, is that correct?
Correct, Your Honor.
All right.
One whole day after
Ms.
today's
Spindle, is there
hearing
anything
is what he
else you wanna
said.
say before I ask the department what they would like in order to not suspend your license?
Okay, well, as you can see, I have a lot of documents in front of me. And I would like to take my full 15 minutes to present all of these documents to yourself and the Department of Revenue.
To the extent the documents are relevant to the issue, to the very narrow issue of whether or not a delinquency currently exists based upon the current orders which currently exist, that's fine. If they are directly relevant to that issue.
All of it is
However,
directly relevant, sir.
okay. What would you like to present?
I would. Okay. I'm currently in my...
The bailiff will get your documents for you.
Okay, thank you. So, first and foremost, the April 27th, 2022 Illinois order is void ab initio.
And Judge, I'm going to object at this time.
Yeah, those matters are already on appeal, I believe, correct?
Yes, and I would appreciate it if I
Everybody has to take a shot every time she says ab initio.
could actually speak. Okay.
Okay, I'll listen to what you have to say if you wish to make a record, but those matters are already on appeal, and I'll not be passing on those matters today.
Yes. So, as I said, that order is void ab initio, as Illinois no longer had jurisdiction under the UCC JEA Florida Statute 61.501, rules as of February 13th, 2022, and is therefore void and cannot be enforced by Florida or Florida Department of Revenue. This morning before I arrived, I e-filed 3 different documents. One is objection to enforcement of unregistered foreign support order. The other is the memorandum of law in opposition of enforcement of an unregistered and improperly registered foreign support order to support the objection. And third is the motion to stay enforcement of driver's license suspension. The $33,000 or whatever is non-existent. It's void ab initio. And it is currently in District 5 Appellate Court. And this week I will also be filing in Florida Supreme Court to argue this entire case. This entire case has been all illegal activity between Justin Serlich, Mary Serlich, and Ira Serlich, Judge Stasia Warren, Serena Baldacchino of Rice Law Firm, and Judge Sanders C. Upchurch. Are all of you familiar with 42 U.S.C. 1983, 1985, and 1986?
And I'm not here to
I
answer your
hope so, because I will be filing that next against all parties that are violating my constitutional rights. I have had
Driving is not a
absolutely no contact with
constitutional
my
right.
children. My ex-husband is hiding my children behind this void ab initio
Judge, I'm gonna
order,
object to
Shot.
while you are not going to object to me or
As to where
violating my
this
constitutional
objection made,
rights.
I will rule upon the objection. What is your objection, Mr. Holt?
Relevance, Judge, as to where the
All of
children
it's
are,
relevant.
have no bearing on today's hearing. Today's
As-
hearing.
If you take away
is
my
a
driver's
negotiation.
license on a void ab initio order, you are
Shot.
violating my constitutional rights, and you will be subjected to 42 U.S.C. 1983, 85, and 86.
This is not a hearing on whether or not the court is going to take away your driver's
Okay.
license. This
So,
is a hearing-
Exhibit
If you
A,
let me finish my sentence, ma'am. This is a hearing.
you're violating my constitutional
This
rights.
is a hearing on your motion requesting that the court interfere with the Department of Revenue's existing statutory authority to suspend the license, which indicates that where any child support delinquency exists, the department may suspend the license. Now, we've already established that there are orders that exist that I understand you disagree with. We've already established that
All
those
void.
orders are on appeal.
All of it is void.
Okay, we've already established those orders are on appeal. I believe the circuit judge disagreed with your assessment of that situation.
Yeah, because she's part of the illegal activity, and she will be subjected to a 42 U.S.C. 1983, 85, and 86.
And those matters, as is your right, are on appeal in the appeals court, okay? And the appeals court will rule upon those matters in due course.
And it will go to Florida Supreme Court, and I will see everyone in federal court.
And that's fine. But unless or until those orders are overturned, those orders still
Okay.
exist.
Objection
And
to
understand that
enforcement.
I'm not a
Number
hearing
2, the
officer.
purported
I'm not
foreign
a circuit
order
judge, I'm a
dated
hearing
April
officer.
27th from
You're gonna
Illinois
talk over me?
has not been properly registered in Florida under Section 88. You cannot enforce something that has not been properly
Stand
registered.
by for a minute.
Taser,
Please
taser,
take all of these
taser.
exhibits. They are in my file. Please hand all
No,
of these to the
she's
Department
not
of Revenue.
Subset.
These are all exhibits. There you go. Violate my rights. I'm going to show you you're violating my rights. You cannot take away my driver's license on a void order.
Sure, I'll look at it. Whatever.
I have an LLC that I am starting from ground up. I just created Orbital Reach Marketing LLC. I am a full-time student at UW Parkside in Kenosha, Wisconsin, online for my MBA in marketing. I'm also in my certified paralegal program online at that same alma mater. I'm a full-time student. I'm a business owner that is creating my own business. I am also a public school teacher. I have filed multiple financial affidavits since November, and they have all been ignored. That financial affidavit shows that I do not have the funds to pay this void order. It was signed by Stasia Warren under the table. It violated my due process. It violated my 14th Amendment. All of it is illegal. All of it is void. Absolutely none of this is legal, sir. None of it. I also am in the middle of onboarding for the federal government for a FEMA reservist position. Good. I have passed the security background check, and here is an email proving that I'm now onboarding with HR as a part-time FEMA reservist. That requires me to have my driver's license to travel to sites that have been deemed a disaster. So if you take my driver's license, you are taking away my federal job.
If you let the hearing officer talk for a moment. Okay, first of all, I am a hearing officer. I am not a circuit judge. I am, as you are, bound by the rulings of the circuit court. Okay? The rulings are in the court file. I can see them, and they do exist. And I took judicial notice of those rulings, as I said, at the beginning of the hearing, along with the payment history. Okay? So I can't ignore the rulings of the circuit judge. Now, the appeals court, if they disagree with the rulings of the circuit judge, could certainly overturn them. Okay? But I don't have that authority.
You can't take away my driver's license with an inability to
I'm not
pay.
here to take away
I'm
your
not
driver's license.
willfully in contempt of anything.
Yes,
I can't
you
be
are.
in willful contempt of a void ab initio order that should not
Shut.
exist.
Yes, sir.
I believe sent you a notice of intent to suspend your driver's license. Is that correct, Mr. Holt?
Yes, Judge.
Okay. And consistent with that notice of intent, you have filed a motion to contest
Correct.
the suspension of your driver's license, which is your right, and that's why we're here. So, I have determined that based upon the orders that have entered, which I understand you don't agree with, and that you believe should be voided, and that matter is currently on appeal in a court that may have the jurisdiction to overturn that, but I certainly don't. There is a delinquency on the case as we all sit here right now.
Void ab initio.
So,
Shut. Yes.
Mr. Holt, it sounds like Ms. Bindle's driver's license could be saved. She's testified under oath that she has a job opportunity that she could avail herself of if she had a driver's license. What is the state, if anything, requesting in order to not suspend her driver's license based on the current notice?
I guess, just for the record, Judge, I've reviewed the documents provided by the respondent. I don't see any evidence of payments made that weren't given
Because I
credit
don't
to.
have income at this time, sir.
She
I'm not in
testified that
willful
she does not have any
contempt.
evidence to present of payments that she's made
So,
for which she's not received credit.
based on the current orders and the clerk's payment affidavit, there is a delinquency.
I'm not in willful contempt,
I didn't say that you were. This is not. a
but
contempt
they
hearing.
are.
And as the court knows, Judge, whether there's a penny delinquency or a significant delinquency, which is the case here, the department's well within its right to take the action that's taken.
So it's very hard to hear him, I know, but he said that they are well within their rights to take action. So they are going to move forward with suspending her driver's license.
So you're going to violate my constitutional rights, on the record.
Ma'am, this is your hearing, you're getting your due
Yeah,
process.
this is
you're
my
getting your-
hearing. I'm
your
informing
right to-
everyone that you are violating my constitutional
I'm
rights
not
as a U.S.
violating your
citizen.
rights. You're not following a court order is why we're here.
Sir, I've never been in willful contempt.
Judge, we're not here for
If
the
you paid
contempt.
attention to my motion to vacate, you would notice that none of this should even exist.
Understand, ma'am, that my
And
main.
you are part of this illegal activity
Ms. Bindle?
if you are continuing to
Ma'am,
violate
Ms.
my
Bindle?
Ma'am,
rights.
if
Ms.
you would like the
Bindle?
hearing to proceed, you would have to have the hearing officer speak.
My function
please.
here was to determine whether a child support delinquency did or did not exist based upon the current orders, which do exist, and I understand.
I'm not in willful contempt.
And I understand that they're on appeal.
And my
Okay?
financial affidavit proves
having
I'm not
been
in willful
said-
contempt. This has been filed with the Department of Revenue.
I
I have filed a change of circumstance, and it is currently in the process.
A child support delinquency does exist, and
And just for the record, Judge, as the court knows, and for the record, under the Florida Rules of Appellate Procedure 9.600, as the court's well aware, child support is one of the exceptions when issues are on appeal. Enforcement continues. Until
Except
that
Justin
issue-
Sirleaf is hiding my children
So-
from me and forcing me to pay my rapist.
In case you didn't hear him, he said child support is a specific, if you don't pay, they can proceed even though it's on appeal. Child support has that exception.
When I'm not in willful contempt.
Judge, the department, as I was stating previously, is well within its right. If she wants the driver's license, $1,000 within 45 days.
$1,000.
And I'm not in willful contempt.
Otherwise, it'll suspend.
I'm not in willful contempt. All of this is void. All of this is void ab initio. You cannot force me to pay anything on a void ab initio order. That is law. Illinois had no
Make it a double.
jurisdiction to sign that April 27, 2022 order, and all of you know it. UCCJEA.
Judge, just for the record, we're not here as to those other issues.
No, you're
We're
here
only
to
for
take
the
away my
driver's
driver's license and a void ab initio order.
license. We're here because you filed a motion, ma'am. You
You're
can withdraw
here
it-
to
you can
violate
withdraw
my
your motion if you
constitutional
want.
rights is what you're here for. And I would like you to take all of these exhibits proving that you're violating my constitutional rights
You
right
can
now.
take all those exhibits and
I will be filing a 42 USC 1983 civil action of deprivation of rights, 42 USC 1985 conspiracy to interfere with civil rights, 42 USC 1985 action for neglect to prevent, and Alan Holt will be part of that suit in federal court that I will be filing.
one moment, please.
Thank you.
The hearing officer determined that based upon the orders, which the hearing officer understands the respondent disagrees with and has on appeal, and may or may not be overturned, that a child support delinquency does exist. Therefore, I am going to recommend an order to Judge Upchurch, who is the circuit judge in this case.
Please hand all of these to him.
Respondent's driver's license shall not be suspended as to this child support case based upon any notices to date if the responding party pays at least $1,000 on the case within 30 days. This is not a purge. I am also going to direct the department to keep the license valid for that 30-day period as to this case in order to provide her with an opportunity to either pay the $1,000, use the driver's license to earn the money to pay the $1,000, or she also has 15 days to file a motion to vacate the order which may result from this recommendation if she chooses to do that. Now, that's up to the judge. That's not up to the hearing officer, what happens with that, okay? So, the hearing is concluded. I thank all the parties. You all
Thank
have
you,
a nice
sir.
rest of your day. And please understand, Ms. Bendel, while I am not on your side, I am also not on the department's side.
I'm on the side of
choose
the
a side,
constitutional
okay?
laws.
And, I don't work for the Department of Revenue. I work for the Circuit Court, okay? So
I am
thank
on the
all-
side of being a U.S. citizen that has equal rights and protection as a constitutional citizen.
The hearing
And
is
I
over.
expect
Hearing is
that to
over.
be
We
treated
need
that
this in
way.
the courtroom.
Thank you, ma'am.
Thank you.
Have a
I'll
good
say it one
I'm
more
a civil
time.
rights advocate,
Please
and
say
I
it one
see
more
what
time.
happened
Please,
for animals.
please. Shh. That's all right. We got plenty of shots in. That would be a fun night. Okay, now, wonder what Judge Upchurch is going to say to her, guys. Oh,
Sit down.
here we go. Let's see.
Hi, good morning, everyone. I am sorry that I am running late this morning. It's one of those life gets in the way moments. Let's go ahead and get started. This is case number 2023-31828 in the matter of the Department of Revenue and Justin Serlick versus Heather Bendel. We're here today to address a couple of different motions that were filed, primarily.
Micah, we all want to.
Ms. Bendel's motion to vacate the child support hearing officer Neil Kaufman's recommended order regarding the driver's license suspension. And then there was a motion to dismiss that motion that was filed by Mr. Holt. I'm going to deny the motion to dismiss and just go ahead and proceed with the hearing today as the motion was filed by Ms. Bendel. So Ms. Bendel, you may now proceed.
Good morning, Your Honor. My name is Heather Bendel, and I appear today pro se to respectfully request that this court vacate the hearing officer's recommendation regarding the suspension of my driver's license for alleged child support non-payment. I raise the following points in support of this motion. The Illinois court that issued the child support order in April 2022 did so without jurisdiction. By February 13th, 2022, my 3 minor children were permanently relocated to Florida, and the Illinois dependency cases had already been closed in December 2021. Under the Uniform Child Custody Jurisdiction Enforcement Act, which Florida also follows, Illinois no longer had legal authority to enter or modify child support or support orders at that time. There is no certificate of service on it, and I was not present nor had an attorney present. Therefore, the child support order being enforced here in Florida is void on its face. A Florida court cannot enforce a foreign judgment that was entered without legal jurisdiction. Enforcement mechanisms like driver's license suspension must rest on a valid, enforceable order. Here, the foundational order is legally defective, and as such, any enforcement action under it, including the suspension, is improper. The hearing officer did not allow me to challenge the validity of the underlying order, nor did they fully evaluate my financial circumstances. I was not given the opportunity to present evidence regarding jurisdiction or ability.
Respectfully, Kelly, you're right.
To pay. This omission violates basic due process principles and the requirement of Rule 12.490E of the Florida Family Law's Rules of Procedure. Your Honor, I am currently unemployed except for my LLC, Orbital Reach Marketing, that I just formed a few months ago. I have had no income since a car accident in April of last year. I am actively seeking clients with my marketing company, but the economy is struggling. I have no access to my children, no tax benefits, no shared custody. I am financially destitute and indigent at this time, and I have been since March of 2024. I have been denied all contact with my children since August 2021. This court is aware that
Do you guys notice on the screen? Down in the bottom left-hand corner? I'm telling you right now, if I was him, Justin is here listening to this hearing. Justin is here. If I was him, I would be giggling every single opportunity I could when she speaks, because she would go ballistic.
I have filed repeated motions to restore visitation and enforce my rights, but those motions have been delayed or denied without a full evidentiary hearing. To suspend my driver's license under these circumstances while simultaneously blocking my access to my children is both punitive and contrary to the best interest of the children.
Money.
Your Honor, I
is best
respectfully
interest of the
assert
children.
that
Money.
this enforcement action amounts to a deprivation of my rights under color of law, especially given that I have not been afforded a fair hearing and the underlying judgment is void. My right to parent my children and to move freely in pursuit of employment and reunification is being compromised by a process that is not grounded in valid legal authority. For these reasons, I respectfully request this court vacate the hearing officer's report in its entirety, deny the recommendation to suspend my license, and consider scheduling a hearing to evaluate the validity of the underlying Illinois order and my ability to comply with any support requirements going forward. I am not here to evade my responsibilities. I am here to restore contact with my children, protect my rights, and follow the law. Thank you, Your Honor.
Thank you. And does Mr. Serlich, do you have a response to the argument that's been made by Ms. Bendel this morning?
No, I mean, I'm not sure why I'm here, honestly.
We're glad you're here.
Something that the state would deal with.
It is. I just wanted to give you an opportunity to go ahead and address the court if you chose to.
No, I have nothing to say. Thank you.
Okay, and it looks like we don't have, you are not Mr. Holt.
I do have a question for Mr. Serlich on the record.
Okay, this is not an evidentiary hearing. This is an argument, so there will not be an opportunity.
I want to know what I'm going to be able to see and speak to my children.
Never, ever, ever.
Yeah, see, that's the problem. He's blocked me on all forms of contact, and you are aware
I
of that.
blocked you too, by the way.
Yeah, because you denied that, and you're violating my rights.
I have a better
Violating my
chance.
constitutional rights.
I have a better chance of going and taking custody of these kids than she ever does.
I'm sorry you feel that way, and I would like to hear from the Department of Revenue. Go ahead, ma'am.
Thank you. Good morning, Your Honor. Chelsea Aubin here, filling in for Paul on behalf of the state, Justin Serlich. And I would just like to answer you the motion that the transcript having to have been provided to the court and counsel within 48 hours. And I understand something was found, however, the transcript file does not conform with Rule 2.53.
Objection. I filed a certified copy on July 4th, and it was served to the department.
Ms. Bendel, Ms. Aben did not interrupt you, and you're not going to be interrupting her. You can respond.
I act as an attorney, and I'm allowed to object.
When she is concluded, you're not going to object during another lawyer's oral argument.
Well, you guys object to me constantly.
You can object when there is testimony that's being proffered. If you interrupt again, I'm going to conclude this hearing without your participation any further. Go ahead, Ms. Aben.
Thank you. I would further like to argue that Ms. Bendel did not point out any error on behalf of the hearing officer, Neil Kaufman, as the state does have the authority to suspend driver's license under 61.13016. Delinquency exists, having been 15 days delinquent, which the arrears affidavit does show. The respondent.
Where is the registered order to enforce?
Ms. Bendel, I am not going to tolerate.
I want to see the registered UIFSA. Where is it?
You are not going to interrupt her again, Ms. Bendel. That is it.
I would like to see the UIFSA registration. Where is it in my docket?
Remove her, Judge.
Thank you. As you can see by the record, the order that the registered here fields have been ruled upon, and the order has been found to be here properly.
Stop. Guys, JK just nailed that timing. JK just nailed that timing. We can't just gloss over that. That was impressive.
$85 a month with an arrears amount of $1,000. The state did request $1,000 in order to keep the license valid. The respondent had recently paid a $1,000 purge, which the $1,000 is well within her ability to pay. While it was not a purge, it was proper for the state to require that within the rule of 61.13016, where the delinquency did exist. The state has nothing further than that.
All right, thank you. Ms. Bendel, at this time, if you'd like to respond, you may do so.
Where is the UIFSA registration of arrearage in my docket, please? It doesn't exist. And that is what I was pointing out on the 17th, June 17th. Where is the arrearage registration in my docket?
Do you have an argument you would like to make, ma'am?
I'm asking a question. If you're going to enforce all of this illegal arrearage, where is the registration of it? It's not even properly registered to be enforced.
Ma'am, I don't know that Ms. Aben or I really understand what it is that you're asking.
UIFSA registration. Florida requires it. Where is it? It was never properly registered in my docket. Mr. Serlich's attorney, Serena Baldacchino, never did it. My attorney didn't do it. So where is it? It does not exist. You are enforcing a child support on a void order that doesn't even have a certificate of service on it. I was never even served with this order prior to it being signed or after it was signed. It is literally illegal. It is a 3-page void order that cannot be enforced for a multitude of reasons. It's void ab initio. It violates my constitutional rights. I was not there when it happened, nor did I have an attorney present.
Disclaimer, do not take pro tips from JK.
I was not served with that 3-page proposed order prior to the hearing happening. I was not served with the signed order afterwards. If you look at that 3-page order, there is no certificate of service on it. Nor was it ever properly registered by my former attorney, who used to be a judge here. No one has been handling this properly, and I'm the one pointing all of the issues out. And now you are violating more of my rights by trying to take away my driver's license on a void ab initio order. So I'm asking, if you guys are going to enforce this, I am requesting, as my right to request this, where is the UIFSA registration of arrearage in my docket? You can't answer that because it does not exist.
I will make a note of your objection. Further that you'd like
you can't enforce an order that was not properly registered.
So noted. Thank you, Ms. Bendel. Is there anything else you'd like to put on the record?
Your finances.
I have zero income. I've had zero income since March of 2024, over a year.
There is a good job for her. Now, not everybody in chat is going to agree with me on this one. Some of you might even think that it's just wrong. But there are actually CEOs and very powerful men who pay large amounts of money to get berated by their prostitute. She would make a freaking fortune berating them.
Where are these numbers coming from? Where did the 1,000 come from? That Mr. Holt, he literally just plucked it out of thin air. $1,000 in 45 days, Your Honor, and she can have her driver's license. You're basically making me pay my ex-husband ransom money to now pay for my driver's license while he continues to withhold any and all contact. Your Honor, I know you have children, and I know you know what is happening is wrong. You need to do the right thing and actually protect my children. That is the oath you took when you took that bench. He is neglecting them. I have been telling you this since January 8th. Tom has attempted suicide in his care. You have hundreds of pages of evidence in my docket that I have been serving you. And it appears as if everyone is blatantly ignoring my cries for help to get my children some much needed help and get me access to them. Morgan v. Morgan, New York, 2023 states that if a parent is choosing to withhold access, child support must be suspended during that time, because that means that the party only cares about monetary and does not care about the children's best interest. So at what point are people going to actually listen to me and start following the laws? Because all of this, since this contempt order was signed, has all been illegal. It is all illegal activity. Serena had Judge Warren sign that under the table and completely bypassed my due process. I have an email from Paige Russo 2 days after Warren signed it saying, I'm sorry, we weren't able to open your financial affidavit. Can you please drop it off to the office? I did that and they refused to take it. So I'm memorialized on the record that no one ever bothered to look at my financial affidavit filed November 19th, showing that I have no ability to pay. And then they added another $1,000 on. Where did that $1,000 come from? So now you're trying to force me
Child
to
support
pay my
arrearages.
rapist, who is withholding any and all contact with my children, $1,785 a month with zero income. You guys have had multiple financial affidavits showing I have zero income and I'm a full-time student. You are absolutely violating my Fifth Amendment rights. You are violating a multitude of my 14th Amendment rights. Troxel v. Granville says that I have a right to my children. You are violating that right. U.S. Supreme Court has made this decision well in advance that my liberties, my constitutional liberties, are also familial contact with my children. I have no access to them at school because he's using this void order to block them at Volusia County schools when it very clearly states reserved, not terminated. What are you guys doing to my children and I? This is absolutely a 42 U.S.C. 1983, 1985, and 1986 complaint in the federal government courts. This is also a tort claim because you are walking all over my constitutional rights.
A tort claim.
And you have been since the day you took my case in December.
This is a tort
So at
claim.
this point, Judge Upchurch, I am asking you to withdraw and recuse yourself from my case on the record. I have filed 2 motions for disqualification, and you deny it. How can you deny your own disqualification? It should not even go in front of you.
I cannot entertain an ora tennis motion to disqualify you.
Well, I filed a writ of prohibition, an emergency writ of prohibition, because now you guys are coming after my driver's license on an order that I have been voicing over and over and over again. There are a multitude of issues with that order, and you continuously violate my due process to my 5th and 14th Amendment rights. I am a human just like you. I am a U.S. citizen just like you.
What I would like to put on the record, if I could please, is that as a courtesy to you, I accepted the transcript that you provided, but it does not comply with the rules of judicial administration, and I will not be doing that in the future. It has to be prepared by a certified...
it is prepared by a certified court reporter. It has a certification.
It was
just because it was done by someone else other than this racketeering circle, because this is a whole racketeering circle, this is RICO.
My point...
And I am a whistleblower, and I have protections as a whistleblower.
A RICO tort case.
My point was simply trying to inform you that I accepted it this time, but I will not be doing it again in the future. Do you have anything further that you want to put on the record, Ms. Mendel?
I'm going to once again reiterate that 3-page order from Illinois is void ab initio. It does not have a certificate of service on it. That renders it void right there on its surface. UCCJEA, it violated jurisdiction. Why would Illinois sign an order when I was a legal resident of Florida?
Entertain arguments that you've already made, ma'am. You've already made your arguments on the record. Is there anything new and not?
When am I going to be able to see and speak to my children? Because right now you are their gatekeeper and you are violating my 14th Amendment rights to liberties to parent my children right now.
This is not a hearing today about time sharing.
I'm letting you know you're violating my rights.
I understand that you feel that way.
No, it's not I feel that way. That is absolute. You are violating my rights.
Is there anything new and novel that you would like to add?
I have no income. I have never been in willful contempt. I have never been in willful contempt. I will say it a 3rd time. I have never been in willful contempt. Judge Warren signed that without reviewing my financial affidavit. Serena Baldacchino of Rice Law Firm proposed that order without reviewing my financial affidavit.
Yourself over and over and over again, and I'm asking you if you have anything new and different to add.
I'm just making sure everyone is fully aware of what you're doing to me right now, because every single person that's aware and not stepping in, that is part of my 1986. You have the ability to stop this collusion and corruption and violating my rights, and you are not.
I understand that you feel that way.
Again, it's a constitutional fact.
Just for you to think that this wasn't a contempt hearing, it was a driver's license hearing, and under 61.1316, 15-day delinquency, and the amount requested was actually less than the ongoing and arrears payment.
Yeah, that's my question. Where is that dollar amount coming from? Where are you plucking that dollar amount from?
Child support arrears.
You
Child
can't
support.
just pluck a number out of thin air. You have to actually go off of a person's income. You have multiple copies of my financial affidavit. Where are you coming up with that number?
I believe I have heard all of the new argument that anyone has to offer the court, so I'm going going to go ahead and conclude today's hearing unless there's anything new and different that you would like.
No, there is an emergency writ of prohibition filed with District 5 Appellant Court right now.
Okay. Well, perhaps they can clear up some of this stuff for you.
Yeah, I would appreciate that because you're enforcing a void order and what you're doing is illegal. You cannot enforce an unregistered void foreign order. You can't.
I understand that you feel that way.
It's a legal fact, ma'am. I'm following the law. You're not. Have a great day, everyone.
And I apologize for starting late today. I do apologize. Thank you.
Thank you, Your Honor. Okay.
Oh, can you hear me now? Okay, I think you can hear. I think it's better now. This next one we're going to is her friend. Okay, it's not her case. It has nothing to do with her children. It's her friend. She is not as loud as this woman, but she's as delusional. All right, she is the only one in the courtroom, which really, really, really pisses Heather Bindle off. I think there were some court watchers that wanted to come into the courtroom with this woman, and they were denied access for some reason. I don't know why, but I could be wrong about that. I do know that she's very upset that this woman is the only woman in the courtroom with the judge and the bailiffs. Here we go. This one ends with a bang. Not as loud, though. It's not a loud bang like the other one.
Mr. Otto, can you hear me?
Yes, Your Honor. Can you hear me?
Sure can. Thank you. Could you just start your video really quick for me, please?
There you go.
Thank you so much. I would imagine you're not going to do a lot of speaking today, Mr. Otto, so if you want to stay muted, that would be okay.
If something's wrong with your screen, Chris? Oh, no. Now you're better. Okay.
Okay.
It's okay. I'm sorry. I meant Mr. Otto. I beg your pardon.
No problem. I get it. Okay, let's go ahead and let just Miss Cole back in.
This is all for Kit Kat. Kit Kat, this is all for you. She's not as bad. She's not as loud. She's just as bad. She's just not as loud.
Good morning.
Allison's audio going?
This was from August of 2025.
Okay, sorry we're running a little late. For our audio, we are here in case number 24 DR 553. The case style is Christopher Otto and Crystal Kolpak. Present in my hybrid courtroom are the parties. I've got Ms. Kolpak here in person. I've got Mr. Otto here virtually. And then I do have attorney Amanda Jacobson, who's representing Mr. Otto. Ms. Kolpak is appearing pro se. Ms. Kolpak, I have a bunch of people in the virtual waiting room, and I know you brought some folks with you today. So most court proceedings are open to the public. I think you've been in my courtroom before on a family law case, but for domestic violence proceedings, they work a little different. A judge has discretion in order to exclude folks from a courtroom when we're talking about domestic violence issues, especially involving minor children, and I'm going to be exercising that discretion today. I don't think this is going to be a terribly long hearing. I have a couple questions for you about just the legal issues involved in your case, and then we're going to go from there. So, Ms. Kolpak, Ms. Jacobson, any preliminary...
This has absolutely nothing to do with Heather's case. So, Heather started a nonprofit or whatever to help other people in her situation. This is one of the other people in her situation that Heather is helping.
Matters we need to address before we jump into the motion.
Yes,
Okay.
I need to make sure my ADA accommodations
Not
are
for
in
me, Your
place.
Honor.
Okay, no problem. So how can I help you with that?
First, I need to make sure the transcription for Microsoft Teams is on and recording. And I need that transcript emailed to me right after the hearing. This
Okay.
is what we had agreed upon.
Sure. Yes. Did you hear her, Ms. Jacobson?
Not at all.
Okay. Would you mind standing at the podium? Is
Yeah,
that
that's
inconvenient for you?
Yeah, should I bring my stuff or can I go back and
Well,
forth?
I just want to see if the microphone works. So if you can stand at that podium, just say something, see if Ms.
Hello?
Jacobson.
Can you hear me?
Can you hear better?
No.
No?
I didn't hear anything.
Okay. Try saying something now.
Hello? Hello?
Any better?
I mean, it's silence. It's
Okay.
It's not like even low talking.
Okay. Joe, it's got to be the microphone, and it might be tied to this for the audio. My microphone's actually active, so that's probably why Ms. Jacobson can hear me. Just give us a second, Ms. Jacobson.
Thank you.
Put it all the way up. Ms. Kolpak, mind saying something?
Hello?
How's that better, Ms. Jacobson? Can you hear it all? No.
The Wi-Fi is trying to catch on.
Okay. Sorry, Ms. Jacobson, we're trying to get through this. I know you got mediation.
It's okay. I've notified the mediator.
While we're fixing the microphones, Ms. Kolpak, I do have the recording going right now, and it is going to go ahead and transcribe the audio for you, okay?
Okay, thank you.
Let me see if I'm getting echo again. I'm not. Whatever we had going this morning, Joe, is what we probably should have had going. I don't think that's working either. That's probably the magic device here.
Never mind, it's flashing.
That's right. They need my expertise. Uh-huh.
Okay. Sorry, Ms. Jacobson. Give us a second. Now that we know it's that microphone, if you want to be comfortable and have a seat, that's totally fine. While Joe's working on this, Ms. Jacobson, I'm just going to work with Ms. Kolpak to see if there's any other preliminary matters. I'm going to repeat what she's telling me just so you are hearing the same thing, okay? So I've addressed the fact about the transcript.
Yeah.
How about now, Ms. Jacobson? Can you hear me?
I can.
And Ms. Kolpak, could you say something?
Test.
Did you hear her?
I can hear her.
Great. Okay. Thank you so much. We got it going.
Okay.
Thank you.
Okay, Ms. Kolpak, were there any other preliminary matters I can help you with?
Well, I guess a few things. I did file several things in this case. One was a motion to consolidate the two cases.
Let me talk about that first, okay? So there's no need to consolidate a family law case with a domestic violence case based on what us family law judges have to do. Under Florida statutes, I actually have to be the judge on both your divorce case and your domestic violence case.
Right, so that's why I just wanted to combine them.
Yeah, but we keep them separate based on statute, okay? Because the rules of domestic violence are very different than the rules of divorce court or paternity court. And so they have a rule that says that in a domestic violence case, I can actually, without anyone asking, take judicial notice of your entire divorce file. So essentially, they are kind of combined. But they have to stay in their separate lanes because they're very different proceedings. Does that make sense?
Yeah, because this was kind of an issue in January when I went up in front of her. He put in there how this is a companion case, and it needs to be kind of together. So that's why I put those in to make sure. And I put in for you judicial notice, to do a judicial review of the entire case. I don't know if you did or not.
I actually took an hour last night and reviewed both files.
Well, this is from 2017.
I understand. It's a lot. Yeah.
I know it is. And I did put that in months ago. But, and then I did file a few other things, the judicial notice and demand for due process.
Okay. I reviewed all that. The motion that we're hearing today are those July 6 motions to dissolve. I did see that you've filed some evidentiary stuff related to that, which is fine.
Yeah.
However, I think we need to address a legal issue first, okay? So I took a lot of time to review your motions. They're essentially two, right? You've got a memorandum of law that you filed on July 6, 2025. That was under docket number 65. And then under docket number 66, we've got an affidavit which is basically in support of the dissolution of the injunction. Okay?
Yes, there's
and I saw both those. I read those in their totality.
Okay.
Here's my question for you. When I review both of those, this case was filed in February of 2024. When I look at the affidavit that you filed in support of this, the only allegation that I see that's after the date of filing of the domestic violence injunction was under paragraph 21 of your affidavit, and it says the following. In September of 2024, I accessed the children's My School Bucks account. I noticed Violet had stopped buying snacks. I emailed the dining director at Sable Point Elementary, who informed me that Chris instructed the school not to allow the children to make any purchases without cash, even though I had deposited funds. Did I read that accurately?
Yeah.
Okay. So here's the conversation I want to have with you. There is do you know the difference between a statute and what I'm going to refer to as case law?
No, I mean, I'm still learning.
No problem. So let me.
I'm learning every day.
Got it.
I'm like way more advanced than I was in April when I came to you.
Sure.
I mean, I'm a lot more organized, but I'm learning every day. So.
Okay.
And it's hard for me to speak to you and articulate because of what I've gone through. So you reading everything is really important.
Yes, ma'am.
Because I may not be able to get through it all.
Yeah, I'm a reader, ma'am. So I read everything. I think Ms. Jacobson will tell you. She's appeared in front of me many times. Sometimes I'm even reading things that the lawyers aren't aware of. So
I mean,
I try
to be
really
honest,
hard to do
that doesn't make me feel good that you and Amanda have worked together many times.
Well, she's often in court, ma'am, and so I don't have control over who appears in my courtroom. Ms. Jacobson is a family lawyer, and her office is in Seminole County, and so she's got lots of cases in Seminole County. I'm sure she would tell you that there's been many times where I've ruled against her, and she probably wasn't very happy with me. Okay, so I want to talk to you though about this case. Okay, so us judges have to follow two things. Okay, when we say what the law is, we have to follow statutes. Those are the laws that our legislature passed. Okay, and then there's something called case law. It's also referred to as stare decisis. Okay, the case law is created by appellate court judges. So in Florida, we have 3 levels of courts, or 4. We've got county court, we've got circuit court, and then we've got appellate courts. And the appellate courts are our District Court of Appeal and our Florida Supreme Court. Okay. We are in the 5th District Court of Appeal.
Yes.
And when someone thinks that I messed something up, they can file an appeal.
Yes,
That
okay.
appeal goes up to the
Yes.
5th DCA, and the 5th DCA has a couple options. They can say, Judge Brzezinski, you got it right, and we don't need to tell anyone else anything about why you got it right. And when they do that, it's called per curiam, okay? When they say, Judge Brzezinski, you got something wrong, they can either just blanket reverse me and not tell me why I'm being reversed.
Yes.
But most of the time, if a judge is being reversed, they will actually write an opinion. And so it's essentially them telling all the other trial judges, hey, Judge Brzezinski got this wrong, but we think it's so important to tell you why. And once they tell us why, all the other judges in the 5th DCA are bound by that precedent, okay?
Yes, okay.
And that's how we help, that's what helps us interpret our laws.
Right.
Because there might be an issue with the interpretation of a piece of language in a statute, and the district court will tell us, trial judges, you didn't interpret that right, you need to interpret it this way, okay? So there is a case out of our 4th DCA which is good precedent, and if there are, and there are cases in the 5th that stand for this proposition earlier, but this is like the most recent version of that, okay? This case came out on October 18, 2023. I'm going to read it. I'm not going to read the whole case, but I'm going to let you know the site. The site is Sheer Mohammed. It's spelled SHEERMOHAMED versus Tozzi, TOZZI. The site for this, so if you wanted to look it up on the internet through Westlaw or LexisNexis or one of the research tools, is 373 Southern 3rd 355, and that is a 4th District Court of Appeal case. It came out in October 18, 2023, so it's very new law, okay? So in order for me to dissolve an injunction, here's what the 5th DCA says, and actually
Kelly,
this case
thank you
cites
so
the
much.
5th DCA,
Thank you.
okay? I'm going to read now from the opinion. It says, for a movement to be entitled to obtain relief on a motion to modify or dissolve a domestic violence injunction, the movement must prove a change in circumstances. That case was Reyes versus Reyes. Reyes is spelled R-E-Y-E-S. The site for that is 104 Southern 3rd 1206. It's a 5th DCA case from 2012. The opinion goes on to say also, and by analogy, a person seeking an extension of a domestic violence injunction must present evidence from which a trial court can determine that a continuing fear exists and that such fear is reasonable based on all the circumstances. They cite to a case called Alkery. Further, on one party's request to subject another party to an examination, the party submitting the request has the burden of showing good cause. So in order for me to dissolve or modify an injunction, or for me to extend an injunction, there are special things I need to find under Florida law. And here it says, for a movement to be entitled to obtain relief on a motion to modify or dissolve, you must show me a prove and change circumstances. When I look at your pleadings that you filed, Ms. Kolpak, there's nothing that you pled that has changed since the issuance of the injunction. I did read this in detail, okay? And it is really focused on things that happened way before the injunction was issued and things involved in your family law case. So as a matter of law, we don't even get into the evidence today. Your motion's legally insufficient for me to go ahead and dissolve the injunction, okay? You have to plead something that would show me that indeed you're going to prove to me that there's been a substantial change since the issue of the injunction that would allow me to dissolve
I did.
it. Okay.
Many changes.
Would
I've
you-
done everything
would
that
you-
I was supposed to do with the final judgment,
Would
and
you
that's
like? Would you like to show me in the two things you filed on July 6th where that is?
what, July 6th.
Yes, ma'am.
what?
That's the motions that we're here on today. It's a memorandum of law and an affidavit supporting your request to dissolve the injunction.
Show you, Judge? She told you she did. That should be enough, Judge. So unfair. This is a violation of her constitutional rights.
So you want to know what has changed? And
No, that's not what I asked you. So what I asked you was, you in order for me to hear something,
Yeah.
you've got to file a motion.
Yeah.
That puts the other side on notice as to what you intend to prove to me today.
Yes.
In Florida, we're something called a fact pleading state, and so you must allege the factual allegations related to what substantial change exists that warrants the dissolution. When I look at the two documents you filed on July 6th, which is what we're here on. These are the
Shut-
motions requesting
yes.
that the injunction be dissolved.
On July 6th, but I filed this back in October.
Okay, so.
So I actually filed in October. That was the injunction. And then I went in front of Judge Herr, and he told me to come back with an attorney, which I have no money, so I can't come back with an attorney. And also, they've all screwed me over. So I feel like I've done what I've needed to do.
So let me take a look at this one. I did review this one as well last night.
You have the memorandums of law. You have my affidavits. I have all my evidence that I was going to present today.
So hold on. So let's move. So let me talk about what I saw in October. Okay. So it says here, I would like this injunction to be removed due to myself not getting a fair hearing. That's an appellate issue. It has nothing to do with a substantial change that would allow for a dissolution of the injunction. Okay. The next allegation. Also, since the filing of the injunction, there has been zero contact between myself and my two children.
That is change.
Okay.
That is change. That's my children.
Ma'am, please don't interrupt me, okay? I'm having a conversation with you about what Florida law says about your allegations. So because, like you said, we have the companion family law case, there's a case out of the 3rd District Court of Appeal called Spano versus Spano. What Spano stands for, the proposition for, is you do not let a domestic violence injunction become
You gotta go
the
actually
primary
go to
forum
work
where we
for
address
that.
time sharing, okay?
That's
We do
what's
that.
happened. She took my entire rights away, everything away, with an injunction that I wasn't even present at. I had no due process. My ADA advocate was there and spoke to Judge Stacy about it, and Judge Stacy was the one who decided to just continue without me. And she's done this to me multiple times, and I am going to sue her federally.
Okay.
I already am in the process.
Fine.
Same with Amanda. That's why I put that intent in. And this injunction should have never been put on me.
Okay.
It should be a void injunction.
All
I
of those
shouldn't even have
issues
to-
are for the appellate court. They're not what we're here on today. If I may finish what I'm telling you, anything related to time sharing, we need to address in your other case, not this case, okay? Pursuant to Spano.
How can I address time sharing when I have this injunction on me?
I'm telling you, the way you do it is file a motion in the family law case to say, Judge, I'm an appropriate person to have time sharing now. You can show me why you're an appropriate person to have time sharing now. You got to show for me the substantial changes under Florida law, because there are 2 tests. There's one in domestic violence court. There's also one in the family law case. Those are 2 separate tests, but they both involve substantial changes. So let me move on to what I'm reading here.
Okay.
They have a sister that they've never met who just turned 1. She has the right to have a relationship with her brother and sister. Again, that has nothing to do with the domestic violence statute and what would constitute a substantial change.
But it has to do with my constitutional rights.
It has to do with Florida Chapter 61.
But
and whether
those laws don't trump the Constitution.
So, ma'am, this is not federal court, okay? We are bound here by the United States Constitution, the Florida Constitution, and Chapter 61, okay? The other problem, though, is that none of this information is contained in your memorandum of law, okay? Let me keep reading from this motion. This injunction has caused severe trauma on myself and my family to the point it affects my everyday living. The substantial change that must be pled has to do with the violence. It has nothing to do with...
There was no violence.
That's an appellate issue.
There's no violence.
I understand. That would be an appellate issue to have addressed at the time that your initial
I
injunction
was
was issued.
in such distress. You have no idea, since my children were taken from me.
I understand.
For no reason.
I understand.
Because I reported child abuse. And then they twisted around that I alienated my ex. He alienated himself by abusing my children. He's still abusing my children to this day. I have police reports of him abusing my children as recent as February of this year. My son wants to kill himself because of his father. This is very serious. This injunction needs to come off.
So what I'm telling you, ma'am, is based on my review of the docket, your motion's legally insufficient. It hasn't pled an appropriate substantial change, and I'm referring to the Shiromed case and Ray's. I've given you the citations for both. Now that you know what the law is, okay, if this is without prejudice, so if something actually has changed since the issuance of the injunction...
Everything has changed. My entire life has changed. I'm lucky to be alive right now and not dead.
Then if you'd like to go ahead and plead an appropriate change in writing, so it gives Ms. Jacobson notice as to what the basis of the change is, I would be happy to consider it at that time. But based on what you filed on July 6th and on October 24th, Both are legally insufficient as a matter of law, and
So
I'm going to be denying
why
both.
would you give me a hearing date if you
Because
thought that?
because you're entitled to one and you asked for one.
So you brought me here just to deny me?
I brought you here for you to have a hearing because you're entitled to a hearing.
I disagree with that.
Okay. So I'm gonna prepare an order coming out of today's proceeding. Okay, you're gonna receive it via email. It's gonna cite to the same citations that I provided you today. My assistant will also provide you with a text copy of the transcript. I just want to reiterate what's in the order. This is an accommodation for you under the ADA. If you intend on appealing me, no problem, but you need to order the audio of the transcript and have it transcribed because that's the only record that can be used, okay? The other thing we put in our order is that is only used for your benefit. These are confidential proceedings. If I find out that anyone's using that transcript for any other purpose than for your disability, it may expose you to contempt sanctions. I just want to make sure you understand that, okay?
I don't know. That went right over my head. So no.
Well, I don't
understand that. I don't understand anything that just happened here today.
Okay.
I feel like you're railroading me just like Judge Stacy did.
Okay.
And I'll add you to the lawsuit.
No problem. I'm just going to remind you one more time since we have the audio here. It is very important. We are providing you with the essentially a text transcript that is not an official record. We're doing that for an accommodation for you for your ADA. That is to remain just for your use in this case. It should not be used for any other purpose.
Yes, for my case. I can use it for my case.
If you use it for any other purpose, including publishing it to third parties, it would expose.
What if they're helping me with my case?
It would expose you to contempt sanctions, including incarceration.
I'm allowed to show these to people that are helping me with my case.
You're allowed to order the audio of today's transcript of today's proceeding, and then have that officially transcribed. If you do that, you can do whatever purpose that's allowed for under Florida law with that transcript. We are accommodating your disability, ma'am. We're accommodating your disability by providing you with this text. It's not something we have to do. I've told court administrators it's something I want to do, but pursuant to the order that I entered related to that, if you use it for any other purpose outside of preparing for your case, it could expose you to contempt sanctions that could include indirect criminal contempt.
So you're threatening me as well?
It's not a threat. It's just reiterating what the order says, okay? Okay, thank you very much.
Another threat from a judge. Thank you.
Ms. Jacobson, anything else?
No, Your Honor.
Okay. We'll take care of preparing this order for you, okay? Okay, thank you. Okay,
you guys are destroying families and children.
If you guys want to start checking people in, that'll be fine.
Blood's on your hands when something happens to my children. It's already escalating. It's been escalating for years. You give children to abusers. Unbelievable. This country's disgusting. And then you wouldn't let any court watchers in because you don't want people knowing what you're actually doing in here. Don't worry, we have many people fighting what's happening. Hope you're proud of yourselves.
Emu Heather.
You wouldn't even let the support dogs in for me? Thanks.
She wanted her support dogs to come in with her. Look, there it is. There's one. A little doggy. Hi, doggy.
You didn't even let me read anything I prepared. You should read this book, Framed. This is about women and their stories that have been just like me. Children taken. I'm unpacking.
Good morning, folks. We'll be right with you, okay?
It's a national rally against family court, September 7th, 8th, and 9th. Look it up. Family court is destroying families. Every judge and person in here will be suing federally. Good luck.
That's a way to start the day.
Good morning, everybody.
I just hope the lady with the dog wins whatever she's here for. Whatever she's here for, I hope she wins today. Fingers crossed. Good boy. Good boy. All right, guys. Whew. We made it. We made it through today. Thank you so much for coming out today. I really appreciate it. Today is Friday? Saturday? Today is Saturday. Shit, I don't even know what today is. Today's Saturday, like I said, guys. Like I was telling you, today is Saturday. So, no stream tomorrow morning. We're going to stream tomorrow night. Or wherever you are in the world, whatever time it is when it's me at night. So, like, 13 and a half hours from now, whatever time that is, that's what time we're going to stream tomorrow. So, yep. I hope you guys have a great day. I hope that you don't sue any judges today. I hope that you don't do that. And I hope that you replay the last clip with a bottle of vodka and just try it. It'll be fun. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,